ये जो वर्कशॉप रखा है हमने आर्बिट्रेशन का, नाउ बिफोर आई स्टार्ट टेलिंग यू कि आर्बिट्रेशन कैसे, हाउ टू ड्राफ्ट एंड एवरीथिंग, जस्ट बिफोर दैट आई जस्ट वांट टू क्लैरिफाई सर्टेन पॉइंट्स कि आर्बिट्रेशन कैसे चलता है। आई एम प्रीटी मच श्योर कि आप सबको पता है कि आर्बिट्रेशन कैसे चलता है, बट लेट्स स्पीक इन अ वेरी डिफरेंट वे कि आर्बिट्रेशन एक ऐसा पर्पस भी हो सकता है कि हम उसको एक अलग नजरिए से भी देख सकते हैं। Everyone knows, everyone, I'm assuming one standard thing that everyone knows what is arbitration. Okay, arbitration हमें ये बताया गया है कि it is an alternative system to justice. It is an alternative area where you can go there and get your matters concluded in a very legal way. Okay, that is fair enough. We appreciate that part. But what if I say that arbitration can take over ABC, if at all we have such laws which can protect arbitration in all the ways? Just think on that part, because I want कि जब मेरा ये 1-1.5 घंटे का जब सेमिनार खत्म होगा, I want someone to tell कि what is there any possibility that arbitration can overcome ABC? Is there any possibility that arbitration can be a solution for 90% of your problems, 100% of commercial and more than 50% of non-commercial? Just think why. If anyone knows why arbitration came into picture, I think answer आप सबको पता होगा. Now, arbitration, maybe 15 years back, there was not such a big interpretation when it came to arbitration. एक simple सा logic था कि आप arbitration का clause रखो, arbitration start करो. Now, how this arbitration changed? Thanks to COVID. Yes, thanks to COVID. Everyone realized the importance of statutory arbitration. Everyone, I mean to say, MSME laws was already there since 2006, but बहुत कम लोग जाते थे MSME में, but because of COVID, everyone realized कि how to go to a court where no fees has to be paid and you can get your matter concluded. And this is where I think arbitration has started gaining more momentum. अब जहाँ जहाँ momentum आता है वहाँ पे restrictions भी आता है, जहाँ जहाँ restrictions नहीं आना चाहिए और वो आ जाता है, so that creates a huge barrier between what you expected, what you read and what is impractical. I personally believe that arbitration has a lot of potential, but there are certain restrictions being made, in my view, that's my personal view, where I think arbitration has been curbed down. I can only hope that restrictions, if it just been deleted, then I'm pretty much sure arbitration will, it will flow like anything. It can be better than any other system what we have as of now. Arbitration एक सिंपल सा चीज है, एक सिंपल सा कानून बनाया हुआ है कि आप अपने हिसाब से रूल्स बनाइए, आप अपने हिसाब से आर्बिट्रेटर को अपॉइंट कीजिए. आर्बिट्रेटर को अगर हम कोर्ट की भाषा में कहें तो जज, बट द रीजन वी डोंट नेम देम एज अ जज बिकॉज जज इज अ जुडिशरी पोस्ट जहां पे एक एलिजिबिलिटी एक क्राइटेरिया होता है. आर्बिट्रेटर का क्राइटेरिया है केप्ट इट वेरी मिनिमल, इसलिए हम उसको आर्बिट्रेटर कहते हैं. कोई जगह पर उसको अंपायर भी कहते हैं. लेट्स वी स्टिक टू आवर आर्बिट्रेटर टर्म. आप अपने हिसाब से आर्बिट्रेटर अपॉइंट करते हो, प्रोसीजर आप डिसाइड करते हो. एडॉक इंस्टीट्यूट एडॉक आर्बिट्रेशंस में आप अपना सिस्टम बनाओ एंड थिंग्स मूव्स वेरी फास्ट. इंस्टीट्यूशनल आर्बिट्रेशन में रूल्स बने हुए होते हैं, यू जस्ट हैव टू इशू देम अ लेटर और आपका आर्बिट्रेशन स्टार्ट हो जाता है. बट जहां पर रूल्स हम बनाने जाते हैं, कभी कभी ये चीज इट हैज अ पिंच ऑफ इट. जैसे कि मोस्ट ऑफ द आर्बिट्रेशंस में होता कैसा है कि स्टैंडर्ड प्रोसीजर इज बीइंग फॉलोड, दैट जिसने केस फाइल किया है हम उसको क्लेमेंट कहते हैं और ऑपोजिट पार्टी को आप रिस्पोंडेंट बोलो, दैट्स योर विश. सो मोस्ट ऑफ द आर्बिट्रेशंस जो एडॉक होता है जहाँ पे वी अपॉइंट एन आर्बिट्रेटर, और व्हेन इट कम्स टू सेक्शन 11 ऑफ बॉम्बे हाई कोर्ट, आई हैव सीन दैट मोस्ट ऑफ द आर्बिट्रेशन में एक सिस्टम बना हुआ है कि यू बोथ फाइल योर एविडेंस पहले एंड देन स्टार्ट योर मैटर. I personally feel it should be depend on the parties whether the evidence should be filed first of claimant and then cross and then respondent. So जहाँ पे simple laws बने हुए होते हैं उसको interpretation करने के भी बहुत मायने change हो जाता है, and जहाँ पे ज़्यादा interpretation होता है वहाँ पे ज़्यादा से ज़्यादा precedents बन जाता है. So I'm pretty much sure if anyone is following the latest precedents and everything, बहुत सारा चीज minutely आ रहा है जो definitely either it is a plus effect or a minus effect. It depends आप उसको कैसे लेते हो. But I am of my personal view that ad hoc arbitration India में तो नहीं चलना चाहिए. It has to be institutional arbitration. That's it. There are many reasons for me which I'll tell you in my workshop कि क्यों ad hoc maybe it is not a time for us which suits here. It has to be institutional. या तो आप ad hoc बनाओ, but a restriction sort of. For me, I personally believe that banks, NBFCs, some companies, they should mandatory follow institutional arbitration and not ad hoc. बस आप अपने हिसाब से आर्बिट्रेशन बनाइए, आप प्रोसीजर फॉलो कीजिए. विद इन 12 months इट हैज टू बी अवार्ड पास करना है. अगर आपको 6 महीने एक्सटेंड लेना है, यू हैव टू टेक द अप्रूवल ऑफ द चीफ जस्टिस एज पर द लॉ. यू टेक द अप्रूवल, 6 महीना और बढ़ जाता है. आफ्टर दैट यू नीड टू गिव अ रीजन टू द कोर्ट you why arbitration was not completed within 18 months. But my personal thing is that majority of the arbitration they gets closed within 12 months, which is no doubt a very good parameter, and it has to be done in such a way. Cost wise, well, if you are a business cost analysis, तो आपको cost थोड़ा महंगा पड़ेगा arbitrations का, no doubt about it. But then अगर आप उसको time के साथ match करते हो, then I'm pretty much sure that it works out in your favor. Now, the whole purpose of me taking this workshop was, I have seen, what I have personally believe is that there are certain stages in arbitration which I think if we are able to understand what is valid arbitration, what is not valid arbitration, how you can counter that particular arbitration. Now, the moment if I am seeing how to counter and what is valid and not valid, orally doesn't have any sense. Everything has to be in writing. Everything has to be in writing, because आप appeal करते हो तो appellate court will never ask you what you spoke in oral, what steps you took. Like जैसे section 16 भी बैठता है, section 11 बैठता है, section 12 बैठता है. Everything has to be in writing. Now, I'm just putting out some illustration. The whole purpose of this illustration is not to make everyone new in writing. I will prefer आप पढ़ के भी आप आंसर दे दो. Is that ये चीज I'm pretty much sure that by the time I complete my 9 illustration, I'm pretty much sure that 50 to 60% of arbitration act has been covered in a very different way. Because जो base cover हो जाता है, then you can take it forward. So मेरा purpose वही है. I want if anyone do read this illustration, I will read out. If anyone has any issues, you tell me. But what I want is you to tell me the 4 points which I have stated, points for you to update. Let me read the clause. Sub Apna Bank has given a car loan to ABC for 5 lakh rupees and the standard agreement was signed. Full stop. There is a reason why I'm using a standard agreement. I want everyone to tell me whether standard agreement is valid or not. That's your part. ABC signed without reading, and in the same, there was a clause of arbitration stating a sole arbitrator. Failure to pay loan, bank issued notices and invoked arbitration. In arbitration notice, they stated that they have appointed Mr. Purushottam as arbitrator. After 3 months, ABC gets notice of arbitrator stating to attend the meeting, and on meeting, the arbitrator named Mrs. Muskan stated ABC of not filing WS, and hence ex parte proceedings will be taken. Now, this is a scenario. Now, what I want from you is, there are my 4 queries. Is arbitration valid? If so, do tell me why. If not, you have to tell me why. Is arbitration has right to move ahead? Arbitrator, is there any delay provisions in arbitration? And how will you draft the application for rejection?
This is actually regarding a standard form contract, sir.
Yes. I meant to say, and nobody reads in it. I don't know about other worlds. Let me be very frank. I have not seen a single person who is reading their bank documents, but they only sign because definitely you want some money. That's it.
Yes. So if the bank policies of instituting the arbitral clause in the standard form contract, so the foremost thing is the arbitration is valid. Now, whether the signatory has read or not read, so in law it is presumed that you better know the laws. You go through the fine print. Yes.
So you are saying it is valid, right?
Yes, as per my examination, it is valid.
Okay.
Please correct if I'm wrong.
Okay.
Secondly, is arbitration has right to move ahead. Yes, arbitrator. Yeah, the arbitrator, the bank has the right to move ahead.
Okay.
By following the requisite procedure.
That
is issuing the section 11 notice.
Okay.
Thirdly, is there any delay provisions in arbitration? And how you will draft the application for rejection, that is from the respondent side.
Yes.
That is the Mr. ABC's concern. Now, how he will draft, he will have to take some time or whatever. Now, you please enlighten us. This is what I felt.
Okay. Is there anyone else who can tell me? Please आप बताइए, because see, end of the day, let me tell you one thing. Law is not about me being correct or you are incorrect. It is all about how we interpret the laws. And at the end of the day, the law has to come to a settlement saying that is there any fair principles of justice being met or not. So law में कुछ सही गलत नहीं होता है. Situation based पे उसको हम सही गलत मानते हैं.
Hi, I would like to understand if the appointment of the sole arbitrator is by both the parties, because sole arbitrator has to be appointed by both the parties.
Okay, but is there any law saying that sole arbitrator should be by both the parties?
So, I mean, if it's included in the draft agreement, then I mean, yes, I mean, the appointment of the sole arbitrator, see, legally speaking, in order to, secure both the parties, it is ideal that the appointment of the sole arbitrator should be by mutual consent.
Okay, I'm taking this point and I'll reply to you. You take an assumption that there was by discretion, it has to be appointed by the bank and they have appointed. Take that as an assumption, and if you can share your views on this 4 point. See, it is relevant. I'm telling you, this is a daily which has been going on, and the illustration which I have given. Let me tell you, if anyone is handling bank arbitration matters and if you are against it, this covers more than 45% of the problem, 45 to 50%. I'm just replying to this part. Let's understand the first part. इस पूरे question में, I mean, there are certain terms which I want to tell you. One is a standard agreement. Definitely, there is a settled law saying that once you sign any agreement, it is binding. That's it. I mean, it is a settled law. But that's my personal belief that if you don't have any other choice and you don't have any other venues to get money at a good interest, I am still of the view that getting signed a standard agreement should not be binding on me. That's my personal view, because it works in the same way. Like consumer court says that, if the RERA says that if the builder signs a standard agreement, the benefit should be given to the buyer. If that logic is applicable to them, then why not to other person? So my personal view is that I am definitely not in that happy mode when I say the standard agreement should be made settled principle of being enforceable. But fair enough, we have to go by the law of land of law. So I'm going that standard agreement is valid. Now I will tell you where the problem comes in this illustration. If you read my illustration very clearly, what has happened is that bank has issued a notice to me, to ABC, saying that कि भाई आप नहीं करोगे तो हम पुरुषोत्तम को आर्बिट्रेटर बनाएंगे. But what has happened is that when he appointed an arbitrator, he appointed other than Purushottam, which is Muskan. So now the question comes, if you tell me that you're appointing Purushottam and then you're appointing Muskan, under what law this arbitration becomes valid? So my answer is, this is invalid, first of all. Now this is where section 21 of the arbitration notice comes into picture. In arbitration law, if you don't issue arbitration invoking notice under section 21, arbitration doesn't start and the limitation doesn't stop. Now what happens in section 21 is that if you have got a right to appoint a sole arbitrator, you need to issue a notice to the opposite party saying that I am appointing, as per clause which I have got the right to appoint, I am appointing Purushottam as an arbitrator. If you have any objection, you let me know within 30 days. Now, if I change my arbitrator from Purushottam to Muskan, that becomes an invalid arbitration. You cannot do that. Even if both the respected arbitrators are good in their own terms, both are a very famous person, both have got a high standing in courts, but that will not make this arbitration proceedings as legal. Because when you issued me 21 notice, I was given 30 days period to reply and give my objection to Purushottam, not to Muskan. So the moment you change the name, that becomes invalid. Now what happens, suppose it becomes invalid, the whole tribunal proceeding gets invalid. So my first answer to this, is arbitration valid? I will say no, never, because not proper invoking notice was issued to ABC. And let me tell you, most of the financial institutions or other than financial, they are in this particular manner. Please read your section 21 notice before you attend any arbitration proceedings. And there is a reason why I stated a specific line that ABC have not filed WS, because if you read arbitration law, if you have any objection in regard to the arbitrator or tribunal, you have to give it before you file WS. The moment you file WS, the moment you accept arbitration, and then you are moving ahead. Okay. Second question, is arbitrator has right to move ahead? Partially yes, partially no. Reason is, if you don't make an application for rejection, he is within his rights to move ahead. If you give a rejection application, legally he doesn't have any stand to be part as an arbitrator, and this tribunal has to be dismissed by law. Is there any delay provision in arbitration? Yes. As I told you, even CPC has it. Okay, and arbitration basically covers civil part. As I told you, arbitration has its own rules and regulations. So when you attend any arbitration, your first, when there's a preliminary meeting which takes place, which takes care कि आपको file कब करना है, आपको कैसे करना है, you should make one provision very clear कि delay होना चाहिए. हाँ, delay का cost आप तय करो, but has to be there. So now the question comes, how you will draft the application for rejection? Can anyone tell me how?
The way to file the rejection application, you have to tell in the application the points that you have mentioned in the illustration, that the arbitrator has been changed unilaterally by the bank and you have not agreed to it. So that is the first point that you need to mention before it is rejected.
Okay.
And you can also say that WS cannot be filed, obviously, and this is my objection. And WS, they're saying, I have not filed WS. I have obviously not filed WS because I am objecting to it first.
Perfect. What you have said, the content is perfect. So I will just read out how, in my view, should be written is that instead of using application for rejection, you have to say application for rejection of under section 12, somewhere you can find out, and section 16 somewhere. What you need to state is that on this date, the arbitration started. On this date, I got section 21 notice. As per section 21 notice, I was informed that within 30 days, I have to give the consent if I have anything against Mr. Purushottam. I have attended this meeting on this date. Today, I'm filing my application for rejection of this particular tribunal because of this reason. One, no proper section 21 notice was issued to me in regard to the present arbitration proceedings held by present arbitrator.
Correct.
As per section dash, this particular tribunal has no legal right to proceed with the matter and hence I request to dismiss. That's it. Prayer A and B. Make it very specific because in case if they don't, you have a right to challenge as an appeal and I'm pretty 100% sure you will win this matter. This is the way you need to make an application. If possible, you don't file your WS because this is what I have seen that they will pressurize you to file a WS on a date. So what you can say is that you can give one more application for extension to file WS.
Okay.
And give a link of that application to this rejection application that in case my rejection application is not accepted, I will file my WS. And you are done with your procedure as per the arbitration line. Simple.
Sir, my question is ki in this first illustration, you said appointment of Purushottam as arbitrator and then the bank changed it to Muskan. What happens when Purushottam is continued as arbitrator? Is the arbitration still valid? Even though we are considering it as a unilateral appointment?
Okay, I got your point that you are asking that suppose if it was not Muskan and Purushottam and it was a sole arbitrator, then whether that particular tribunal was valid or not, right? So let me tell you, there are two ways of understanding how it works. Now, what has happened is that arbitration of a sole arbitrator can only be done as per the clause agreed by you. Okay, it cannot be denied that every sole arbitrator is partial or impartial. Okay, and there are laws, there are schedules being given by the Bombay High Court and the Act that any arbitrator who acts as an arbitrator has to give an application, if to the High Court and to the parties that I don't have any relation with A and B claimant. Right now, the question comes: how you will know whether this sole arbitrator is partial or not? Now, what the law says is that law has given a choice saying that sole arbitrator should not be appointed, which is unfair to the opposite party. Unfair. But you need to be very clear that this unfair will only prevail to you if you are not aware of the arbitration proceedings and you don't know anything. But suppose if you sit on the paper for till WS is filed and evidence has been taken on record, suppose if interim is passed, then you cannot go to the court and saying that the sole arbitrator was appointed partially. There are certain guidelines to it, which the law has made very clear. Yes, no doubt, sole arbitrator today because it happened in Loot. There was a company by the name Loot, which filed a case against Reliance Capital saying that they appointed an arbitrator without my consent. And then the standard was passed that it cannot be appointed unless and until you take the consent of the opposite party. And that's why there's a clause saying that in case you have any issues, you let us know within 30 days. And now there's a schedule. So what is happening is that most of them, we don't put a fight on the sole arbitrator. We wait till evidence comes and then we think of doing that. So don't do that. Whatever you want to do, you do before filing your WS. Because once you start your filing your WS, it means you have accepted them as an arbitrator and now move on. And suppose if the arbitrator has complied with the provisions of no conflicting part, so you can do that.
While invocation of the arbitration clause, kindly clarify it is section 11 or section 21.
21. Section 11 is for the appointment you, and we need to go to the Bombay High Court. The moment you issue section 21, what you say is I am invoking the arbitration as per the clause mentioned in the agreement. You give the extent of the clause and then you mention कि आपने किसको appoint किया as per the clause agreed between you.
No, the doubt is that we have to send a section 11 notice invoking the clause or section 21 notice invoking the
21. See, section 11 is appointment of arbitrator. 21 is invoking. So there is a difference between them. Now, why there is a specific it. If you read section 21 along with section 43 and the Limitation Act.
Yes.
How many of you know that in arbitration act, what happens is, suppose your limitation stops the moment you issue 21 notice. Now, if you don't issue section 21 notice, your limitation doesn't stop and it will end. And the moment it is end, you know that in recovery matters, after 3 years, you cannot make any case.
Yes.
But arbitration, there is a provision saying that the moment you issue invoking notice of 21, limitation stops. And then after 2-3 years, you file your section 11, that's your choice.
Okay.
Now, I'm asking one query and then there's an illustration. This is a query saying that can an unregistered partnership firm having an arbitration clause or not? Suppose if they have arbitration clause against a third party, can an unregistered partnership firm file arbitration against third party as per Indian Partnership Act? Yes or no, to be read with arbitration law.
So as per the recent ruling by Honorable Supreme Court, as per Partnership Act, the word says that they cannot file a suit. Whereas the Honorable Court had ruled that arbitration is not a suit within the definition of CPC, and hence an unregistered partnership firm can invoke arbitration according to the arbitration agreement if they are having any.
Perfect. I mean to say it's a very standard principle of 2019 saying that even if the partnership is unregistered, they can file a claim against third party in an arbitration. If you ask me personally, I still feel that if we can give such, in fact, this is one of the reasons why I say that arbitration has become the major part, because in court you have got limitations, but in arbitration things are just moving beyond limitations. So it's better to move to arbitration. In fact, this particular illustration was the same thing, that if during the continuance of the partnership any dispute touching within the partners, the same shall be easily decided by arbitration if the parties so determine. Fair enough. I'm not getting into, I'm just repeating. Unregistered firm definitely can file an arbitration claim even if they are not registered, as even though there is a hindrance of section 69A, because the Supreme Court has settled the law that there's a difference between a suit and a claim. So in arbitration, there is no suit, it is just a claim. It's a pure case of how words are being interpreted just to benefit someone in the sense how to make, someone moving towards an arbitration. Because someone will make a claim कि अगर आपने arbitration allowed किया, then why not court? But as I said, law एक CPC होता है, वो एक arbitration होता है. So arbitration has become little bit more of a flexible. ये illustration में, can the partners go to arbitration even if there's a dispute between them? This is the clause. This is a clause in an agreement, in a deed of partnership. Okay, now partners have fight it out. They have some issues. My question is whether the partners can refer the matter to arbitration or not.
Yes, sir. In their arbitration agreement, there was a existing arbitration clause.
Yeah, this is the clause. I mean, this is the clause it had.
So, as per my view, if the partners mutually agree upon for appointment of an arbitrator along with referring the dispute to the arbitral tribunal, if they mutually agree upon, a resolution can be passed to that effect and they may join in the entire arbitral process. Correct.
What you are saying, I am agreeing to that part, in case if they agree. But my question is whether this clause can invoke arbitration directly or not.
A plain reading, grammatical and cognate expression of the clause suggests that they are entitled to appoint an arbitrator.
Okay, so let me tell you, this is this particular example is very clear on how interpretations can be done. Now, in this particular case, what has happened is that arbitration was not allowed because what was ruled by the Supreme Court, saying that there has to be a flow, there has to be an intention towards arbitration. If not, then arbitration cannot be referred. So what has happened when this particular matter came before the Supreme Court? I'll give you the citation. Don't worry after this, of Jagdish Chandra, saying that since there is no flow of the words which shows the intention to attract the arbitration, and hence arbitration is invalid. So what I'm trying to say is that it's better to use very simple words, and when it comes to drafting, let's not make it very complicated. It is not mandatory कि आप complicate करोगे, then only you will be called as a good lawyer. A good lawyer means that you should know how to make complex things very simple and simple things more easy for your clients.
It is mentioned shall be referred. The word shall is there.
Shall be mutual. That's what I'm saying. See, I'll tell you what has happened is that shall be mutually decided. So basically what it happens that you have given one more step to the partners कि आप अग्री करोगे तो ही मैं जाऊंगा. बट यहाँ पर एक बार एक बार जब फाइट हो जाता है ना म्यूचुअली में, आप you and me are talking in a very good terms, so we agree to everything. Now we are not in good terms. Now I am a default partner and you are not default partner. Do you really think I will agree to arbitration? I will not. So your clause has to be end. I mean to say, यहाँ पर अगर ऐसे होता ना, the same shall be referred to arbitration, finished. Then yes. यहाँ पे क्या लिखा है, shall be mutually decided by the partners. मतलब you have given an open ended कि अगर आप decide करोगे तो ही होगा.
Clear.
So this is the way it works. The reason I am stating this, because when I started my lecture, I used that there are certain restrictions which are put. I personally feel that if, like in deed of partnership, there are dispute between the partners, even if there is a reference to arbitration, mandatory should be given to arbitration, because there is no purpose of making this arbitration invalid and they going to the court and fight, because end of the day economy business पे चलता है. आप business वालों को सुविधा दे दो. The moment they put arbitration word, the law should say intention was there, डाल दो arbitration. But then again, it doesn't work the way I want. That's it. My question is very clear. This is one of the clause from an agreement. I want anyone to tell me if now the matter can be taken to arbitration or not.
First thing is that if they can be conciled mutually, that is fair. If not, both parties have to agree for an arbitration, for the arbitration to be initiated. If both parties do not agree to the arbitration, then the arbitration cannot be invoked.
So should I take your answer as no? Because what I want is, suppose if there are dispute between parties now, and one of the parties is saying that I am going to arbitration based on this clause. So do you really think that he making such an issuance of notice will make other party binding for arbitration?
No, one cannot force the other party to arbitration if the other party does not consent to it.
So now you are perfectly right. So again, the way it was interpreted by the Honorable Court is like this. What the court said, even I feel the court was very much clear. As I told you in my illustration number 2, that the flow and the intention has to be clear. So what is happening in this particular matter was, there was a clear case that the party should be settled through consultation. I mean to say, then there is a semicolon saying that the parties agreed कि dispute होगा, will go with consultation first. If consultation fails, it has to go to arbitration. That's it. So what has happened in this matter, when it came before the court said कि I can sense that there is an end to this clause. I am not finding anything beyond this clause. I mean to say, there is a full stop to something which brings the intention of the parties, saying that कि आप consultation करो, consultation fail हुआ, then treatment to the arbitration body. That's it. So definitely it became a very valid clause for arbitration. But my personal view in this matter was same, that whether such a simple line, when we say only arbitration, whether this matter should be taken to arbitration or not. But as I told you, the arbitration has become a flexible. And that's why majority of the cases, where even there is a term should be used, it should be sent to arbitration. Make it very simple. But yes, in this particular case, the court has stated that it becomes a valid binding arbitration and go for it.
By consultation, do you mean, is it a conciliation or a negotiation? Or consultation is a different word?
I know. See, this happens, when out of the box. It happens when you copy paste from the Google nowadays, because many of them want just a simple thing, copy paste कर लो online. ओके, कंसल्टेशन ज्यादातर बिजनेस में हम इसको मीडिएशन मानते हैं या तो नेगोशिएशन मानते हैं. इंडिया में दोनों लीगल नहीं. ओके, इवन कंसीलिएशन इफ यू टेक, इट इज नॉट लीगल अनलेस एंड अनटिल वी मेक इट बाइंडिंग. So for me to tell this consultation, I will say that this is more of a mediation. That's it. More of a mediation. Because negotiation doesn't happen when there's a dispute. Negotiation is always prior to entering into an agreement. Mediation is always comes when there's a dispute. So I'll prefer to say this particular consultation word for me in this matter was more of a mediation rather than negotiation or else.
Thank you.
Regarding this illustration number 2, I have got a point. The same may be mutually decided by partners, shall be mutually decided by the parties, or shall be referred for arbitration if the parties so determine. That is what is stated there. Here, there is no flow is not there.
That's what I'm saying. Because what has happened in this clause was, or ke pehle you have told ki partners will decide, and then there is a point if the parties so determine. Most of the times we make very complex sentence. Now what has happened in this way, that the same shall be mutually decided by the partners, full stop. For an example,
Yes.
there was no mutual consent. So now comes the later part, or shall be referred to the arbitration if the parties so determine. So again, the earlier sentence and this sentence has the same meaning.
And it is not conclusive. So determine is not conclusive.
Yes, there is no conclusive. It's an open-ended. In fact, there has to be some another line also to this particular clause.
And normally, I have seen in clauses, what I have seen in clauses is that if they are not able to come to a conclusion or not conclude the mediation, they shall proceed to arbitration by mutual. They shall proceed to arbitration by mutual consent.
So I would have reframed this sentence like this. If during the continuance of the partnership or at any time afterwards, comma, any dispute touching the partnership arises between the partners, the same shall be mutually decided by the partners if the parties so determine, or shall be referred to arbitration.
Okay.
Then there is a full stop. Then there is a flow. There is an intention, even though you have not mentioned 1940, 1996 or 2015, but then there is an intention and then there is a flow.
Okay.
Yes. A company by the name ABC makes sale of wheat to another company XYZ and thereby also raise the invoice. The invoice have an arbitration clause. I want at least someone to tell me whether that particular arbitration clause is binding or not. And I'm telling you, this is the majority of MSME problems. Even though if they are not registered as MSME, this is one of the biggest problems right now.
Yes, sir, I don't think it is binding.
Okay.
It has been mentioned at the back of an invoice, and there is consent of the other party on that.
But suppose if it is mentioned not at the back, but at the bottom of the invoice, then?
Yes, it is not valid till such time the other party signs that invoice and gives the copy back to them.
Okay. Now, what has happened in this particular, contract? In Indian Contract Act, there is a term which is being called as unilateral contract, and then there is a term which is called as bilateral contract. So now let's understand what is unilateral and bilateral. Now, unilateral contract means it's a one-sided. जैसे bank करता है, RERA करता है, a builder, one-sided. We don't have any other option. One-sided आ गया, हमने accept कर लिया. Some law says it is valid, जैसे बैंक में हो गया. Someone says it is not valid. Bilateral means consensus ad idem. So both the parties are aware what is being signed. So now the question comes whether invoice amounts to unilateral contract or bilateral. So the interpretation which is being given is, in one of the latest judgment, one High Court have said invoices is a unilateral contract and hence arbitration is not valid. Another High Court of a different state has said invoice being part of bilateral contract expresses the intention and hence it is binding. So today if you ask me, there are two laws which is going on, valid and invalid. Now definitely there are certain views. If you go by Supreme Court cases of 2022, it has been stated that yes, it is valid. But the question comes, if it was valid, then the latest judgment should have not come. Now if you see from that perspective, unilateral or not, if you print on the back side and you raise the invoice, the question comes whether the invoice bears the signature of the opposite party or not. My personal view, if I go with the legal, pure technical, invoice is raised by A, there is no purchase order, there is no terms, right? Basically, most of them, they only argue on commercial terms. I raise the invoice, I give the e-way bill, I issue the challan. The other party has never seen the arbitration clause. If such a case arises, then how it becomes binding? It should not be made binding. That's it. For me, it should not be made. But I always believe in another way, that since invoice has been raised and today e-way challan has become mandatory, and post invoice, if you are making a payment, then it should be valid. Suppose if you make an advance payment and then the invoice is being issued and then the dispute arises of partial payment, then arbitration should not be held valid. This is the way I interpret. But as of now, what I have stated, one court have said unilateral not valid, another court have stated valid. And that is the Supreme Court of 2002 saying that it is valid. So pretty much sure I mean to say the law will prevail. But for me, the interpretation of argument is like this. If I pay you in advance part and then you raise the invoice and that invoice contains arbitration clause, it should not be made binding on me because I never agreed to your arbitration before payment. But suppose if I make the payment 100% after raising of invoice, then make it valid, because end of the day, more and more commercial matters should go to arbitration, because we know how it works when it comes to other than arbitration. It takes years of it. So this is my answer, law answer, and what the Supreme Court has stated. Anyone has any other view, please let me know.
I agree with you. Your answer follows section 7, clause 4, subclause A and B.
Okay. Even if you go to Sale of Goods Act, it comes into picture.
Yes.
So if you read Indian contract along with Sale of Goods Act and along with Arbitration Act, then it makes a whole scenario. But trust me, I am expecting a good landmark judgment in invoice, maybe in coming years, because this is one of the biggest problem and issue for a businessman, because most of them, they don't enter into purchase order. They only issue the invoice. अच्छा, many of them you might be knowing that consumer court ने बहुत पहले ही बोल दिया था कि अगर आप बिल में लिखते हो goods once sold cannot be taken but has no value, because sale of goods act is very clear. If you sell the goods which is not of merchantable quality, it has to be taken back. So anything you put in invoice doesn't make that valid terms unless and until opposite party have agreed to it. So till now there's a debate. So I'm expecting, but as of now, let's follow the law. What is there?
Correct. Thank you.
Sir, one more thing.
Please.
I agree. This is the same issue which is going on live in IBC cases also. But the thing is, what happens in when there is a continuity of transactions, when there is a running account maintained, so even after, yes. So even after the issuance of invoices, let's say objection is not made to the invoice, and in order to maintain business continuity and in order to maintain the running account, the payment has been made. What according to you should be the
go for arbitration? Go for arbitration. I'll tell you why. Because see, contract law says consensus ad idem. Simple. I always believe in this word. कि opposite party को पता है ना क्या हो रहा है. That's it. Simple. Go with that fact and go for arbitration. Simple. Make it very clear to the court saying that there was an intention of the parties to go this matter for an arbitration, because when I raised my first invoice, he made me 100 rupees. When I raised my second invoice, he paid me 200 against 500. And there is a FIFO account which has been going on, first in, first out. So he is aware of my invoice since more than 4 months. Now I have to go to arbitration. There will be a debate whether arbitration clause is, I don't know how the clause will be put in the, कौन कैसे clause डालता है. But if it is a very reasonable clause, go for it. But I'll tell you the way out. What I have realized in this 15 years, the way courts work, try to go for institutional arbitration and not for sole arbitrator. Because again, I'm of the view that ad hoc arbitration should be closed in India as of now, because the environment is not there. That's my personal view. Go for institutional arbitration, because institutional arbitration have gained the goodwill of the courts. So even if assuming, there is an invoice which is taken care as unilateral contract, but I'm pretty much sure that if you make an argument that sending this matter to arbitration through institutional will not harm any party, I'm 100% sure court will agree to this point. So choose institutional arbitration rather than ad hoc, because I don't feel ad hoc will do any justice unless and until we have a good environment to take care of that part. So That's my personal view. Even if there's an invoice, go for an institutional arbitration like Bombay Chamber of Commerce, Nana Palkiwala, IIAM sort of, go for it. They have got a very good bill of a high value, and courts are aware how they works. And because many of the retired big people are part of as an arbitrator, so go for it.
Hi. Yes, in this case, it is going to be valid because it is pretty clear in their agreement that a sole arbitrator will be appointed. So a notice has been sent for that.
Okay.
Here a notice has to be sent about the appointment of the sole arbitrator first.
Okay.
If the appointment of the sole arbitrator is by mutual agreement, so that has to be notified to the other party.
Fair enough. Okay. This particular thing, as you know, again, this is one of the major issues which is going around. One law says that the moment you agree to a standard agreement, comply with that. Other law says if an arbitrator is appointed sole, then it doesn't take into picture the other party's consent. So some has said valid, someone has said invalid. But what Supreme Court have said is that in case if an arbitrator is appointed unilaterally, I mean to say they have not given any, suppose even if they have issued section 21 notice, okay, and what happens in most of the time that I'm taking a scenario where bank issues a notice or financial institutions or NBFCs or big companies to a small person like a farmer ho gaya, unorganized MSME ho gaya. They don't understand how arbitration works because as I told you, still the environment is not there in India for arbitration. We only hear the arbitration only from urban areas and little bit of semi-urban or little bit of rural. But majority of them आज भी उनको नहीं पता है what is arbitration. उनको आज भी ऐसे लगता है arbitration बोले तो बैठ के बात करो. In that particular scenario, the things which has come out is, taking this as a scenario, saying that अगर आप unilaterally appoint करते हो और opposite party को notice मिला भी होगा, उसको तो पता ही नहीं क्या हो रहा है, then it is not valid. I will share one best example why it should be taken as invalid. Now, what has happened is that one of our client, he got an order, interim order under section 17 of Arbitration Act, saying that an order has been passed against you and all your stocks and everything is being taken care of. You cannot sell it and everything, and they have appointed someone कि आपको ये रोकना पड़ेगा because it has been interim relief, injunction आ गया. Now this person when he got the notice, he told कि मुझे तो पता ही नहीं है notice आया क्यों और ये order कैसे आया. So when we read the whole paper, I'll tell you the dates, the way arbitration worked out. I'm taking a scenario, just an example. Today is 22nd, right? Today is 22nd. 1st July, arbitrator is appointed. 7th July, commencement issued notice. After 1 week, conflict notice is issued. Then suddenly he files section 17 and he issues the notice saying that this is an interim argument. And on 22nd July, interim order is passed. I am receiving the interim order on 31st July. So now the question comes, एक महीने में everything has been done. But the opposite party, even though he received the notice, he never opened the envelope because he is not aware how it works out. In that case, that particular sole arbitrator, whatever he did is invalid. I am pretty much sure there will be a debate why and so and because when we serve the notice, it is taken to be a dim. But as I told you, it is a debatable point because there is no environment. So definitely we will see the opposite party, wo kaun hai, how the system is, and then these particular things will come out in a different way, different words. ऐसा anything, and I'm pretty much sure मैं expect कर रहा हूँ इसमें 2-3 query, but if anyone has any query or something, please let me know.
So there is one thing with this illustration I would like to point out that if L invokes arbitration and the other side doesn't reply to the notice, isn't the arbitrator's authority invalid? Because we have to first look at section 11. When you have to file a petition in the High Court to appointment of an arbitration failing the agreement, isn't that valid when you file an application under section 11? And directly going to arbitration with only one letter is not valid as such, I feel.
Okay. But how section 11 works is like this. Arbitration, when the act came, they gave the power to the parties to decide how you want to run arbitration. Okay. But law has given the guidelines that you don't go beyond this. Now, what do you mean beyond? You cannot appoint 2 arbitrators. You have to be odd. 1, 3, 5, 7, 9. So law ने आपको एक guideline दे दिया है. Now you decide your own rules and regulations. Now how section 11 works? Suppose if there is a clause that in case of any dispute arise, both the parties will mutually agree for an arbitrator, sole arbitrator. The seat and the venue shall be Mumbai. An award shall be passed within 12 months. The losing party will bear all the loss and everything. Then I issue a notice to saying that I want to appoint an arbitrator, and I have appointed an arbitrator, Mr. Lalit Jain. In case you have any issues, let me know within 30 days. He doesn't reply in 30 days. He has received the notice, but he has not replied. Now, this is where I have to go to the Bombay High Court, where the jurisdiction is, that I have to file a section 11 petition because there is no given right to me to appoint an arbitrator, but there was a mutual consent. Now, he failed to give his consent, so I don't have any other option but to approach the court and get an order. Now, suppose if I have a clause like this, in case of any dispute, A has a right to appoint a sole arbitrator having a minimum of 15 years of experience, assuming, as an arbitrator, and the intimation should be given to the opposite party in case of any dispute arises. Even this has a two answer. Suppose if I have a case against A, then A cannot appoint a sole arbitrator unless and until I am giving the consent. So I am pretty much taking that part into, and section 11 come into picture, and again section 16 will come into picture. But suppose if A wants to file a case, in most of the case banks, they appoint. It becomes valid. So it totally depends on the situation. Opposite party will receive a notice and not reply, it is bad. He receives the notice, he doesn't open the envelope, it might be taken as not bad because he is not aware what is going on. So it totally depends on the situation of the case. Now, most of the times what we understand is that once the precedent is passed, that precedent will become the law. I don't take that as a law. What I see is that if that particular order was passed based on certain situation and facts. So unless and until your case fits near and by to that particular situation, that will not be precedent in your matter. Precedent works in that way. For me, personally, when I see the law, because if you take everything as a precedent and it doesn't match with your situation and facts, you cannot. Okay, I'll tell you one example, which for me, it's like law says, once you issue a notice, it is to be taken as served, right? Now, what has happened in one of the case, that the name of the defendant was Lalit Jain, Andheri East. Okay. Opposite party, he issues a notice going to the postal office, and the postal office, what he writes is Andheri East, dated Falana Khatam. The matter reaches the court. And then there is an argument. I am saying that the notice was never served. Opposite party says this is the judgment, saying that once the notice is issued, it is to be taken as a served. What the law says, notice has to be issued to the correct address. So then I have shown the envelope to the court saying that कि पूरे postal receipt में where is the name of the person जिसके ऊपर issue हुआ है, and the matter came in my favor. So facts and situation should make a precedent. It is not that the precedent बन गया तो everything will become a precedent. If we can get into that concept, I think it will be fantastic. 7, 8, and 9. There are 3 queries. I don't want to answer. When I'll complete, आप पढ़ते रहना, you have to answer me. But now let me go through some, I have been told कि किस तरीके से, the things are being shaped up. And what I have seen in arbitration, I am just sharing that part. How the statement of claim is being drafted, how statement of defense is being drafted. But before that, I want to know from most of you, what are your points that you take care when the first meeting happens with respected arbitrator? Can someone tell me? And what are the points you should ensure that this point should come on the very first date of the meeting and not after it? Can someone tell me? Because your first plenary meeting is the place where you decide how this arbitration will be taken care of.
Sir, first brief about the facts of the case and the contract agreement entered into. And then secondly, very quickly and briefly in a chronological order, narrate what are the incidents that have happened. And third, what are the points of dispute. And fourth, what is the relief that you look forward to in arbitration?
Okay. This is what you intend to prove in your first meeting, right?
Yes. We have to have a schedule of arbitration. We have to agree on the schedule of arbitration also.
Okay. Anything else?
Sir, I think preliminary objections should be taken first. For instance, limitation aspect should be taken care of.
Okay. Okay.
And then if you want to object to the arbitrator also, so then the objection should be placed on record.
Okay.
Appointment of arbitrator and the jurisdiction should be was discussed.
Okay.
The preliminary meeting on
Ah.
which the arbitrator appoints is appointed.
Hmm.
On that day, firstly, he shall ask for a memo of the parties. There should be a clear clarification as to who the claimants are, along with their postal addresses, cell numbers, and email IDs compulsorily.
Okay.
The same shall apply to the respondents.
Okay.
Secondly, the jurisdiction has to be clarified because he has to enter upon the arbitral proceedings.
Okay.
Thirdly, the important case is that timelines are to be ascertained regarding filing of SOC, filing of SOD, counterclaims if any, etc. And fourthly, the fees. But the fee portion is only decided after the counterclaim and all monetary aggregates are put forth. So that is definitely on a later stage. But if the arbitrator feels that certain fees, but normally that is not the practice that per hearing he gets. It is only after the counterclaim is filed.
Okay.
So these things happen in the preliminary things. As far as Section 9 or Section 17 is concerned, as the case may be, these timelines are urgently set up if there is a requirement of an urgent hearing following the overall time frame of the ANC Act. This thing happens in the very first preliminary. We can call it as an introductory. Please highlight on this, sir.
Okay. Then I have pointed out. I will just read out the way I put it in my meeting. Okay, there are two ways. One, if the arbitrator is appointed through Section 11 through court, then one thing is very clear that then you will not discuss about jurisdiction of arbitrator. I'm pretty much sure, because like if you in Bombay High Court, they appoints an arbitrator, then you cannot speak about jurisdiction, because this thing you can always speak when the Section 11 petition is filed before the Bombay High Court, Honorable High Court. So that one thing makes very clear. Okay, I'm just going scenario by scenario. Irrespective, if arbitrator is appointed. Now, what generally I believe we should do is, if anyone is aware the new Commercial Code Act has come, I think that is the best way. Just go through that bare act and make your preliminary meeting of arbitrators same manner. The first thing, when you said memo of parties, no doubt it has to be the part of it. Then definitely jurisdiction, as I told you, if it is appointed through court, there is no reason for doing this. But if not, then I'll come to this later, because if you're a defendant lawyer, then you should not speak of jurisdiction, because you should never attend the meeting. Let them waste 4-5 days and then you go and appear and then take the call of rejection. My first illustration, if you're a defendant lawyer. But if you're a very person saying that no, mujhe pehle date pe reject karna hai, then definitely you raise that point, because the moment you try to raise the jurisdiction first point, I'm pretty much sure that all the meeting will be cancelled. They will only say you speak about jurisdiction first. Then definitely timelines and everything. Fees, take it from me. There is already a schedule being given by the High Court saying that these are the fees has to be taken. So definitely it will be taken care by that particular act. Or if there is any other than different, definitely when the counterclaim comes, everything becomes one part and claim becomes one part. What I'm more interested in is two more things. One, dates. What if the dates are not matched by? Then there's a delay comes. So try to put delay particular point on a very first date. In case if there is a delay, the delay should be allowed with the cost of rupees X amount. If there is a second delay should be allowed with the cost of second amount. If there is no compliance of second delay and first delay, third delay should not be taken into consideration unless and until it is very urgency or force majeure and the matter has to be expedited. Make this point the basic point in that meeting and put a cost. Because the moment you put the cost of 25,000, 30,000, opposite party understands if I don't do this, I have to pay 25,000. Cost is the best way to make other party deterrent to avoid doing things. Go for it. Make things very clear. Your timeline has to be very clear. I am speaking for claimant. Now, if I speak to defendant, what I want them to make it very clear is when you need to file your evidence, you need to play smart. Suppose because most of the time what happens is that we see an prelim meeting order saying that both the parties should file evidence first and then take the matter. But if you're a defendant, tell them, no, let them file evidence claimant. I will take the cross. If definitely it doesn't prove via documentary evidence, you take the cross. And then I will file my evidence if I feel so after taking the cross. Because as a defendant, don't open your defense on the very first date by submitting the document. As a lawyer, you should never do that, because the defense is all about you have. If you open your defense on a very first date, then so make your strategy very clear to whom you are appearing to. Make that very clear. When you said a memo of parties, I prefer, because it basically go for an active email ID, and then go for which online servicing you are using. Make everything a part of record in your first plenary meeting. Because I have seen that the first meet, when we jotted out the points, when you make out, what we do is we leave many points and then we say we will decide later on. Don't do that. Make it on the very first day. This is the first job we should do when we appear in arbitration. Because the moment your first meeting completes everything becomes easy, because now you know when the matter will be completed. Because you have bifurcated everything. First delay, second delay, and third delay. And you know when the matter is completed. So it works in that way. Put it everything. Now, suppose if there is a section 17 application, suppose if there is already section 9, and then the matter is referred to arbitration, and then if the order is there to file 17 or section 9 will be continued till arbitration works out, fair. If section 9 works in that way, then there is no need of 17, because interim is already there in market. Suppose if the order is passed in section 9 saying that it is valid till arbitral tribunal is constituted, then definitely you need to file section 17. Then you also ensure as a claimant within which how many dates you need to get your section 17 done, and no delay should be allowed in doing so. And you can take a reference to section 9. But if you ask me as a lawyer, I will always prefer that you go for section 9 and 11 together, because by the time section 17 comes into picture, by the time arbitral tribunal is constituted, you might lose everything what you are claiming for. So the best option is go for section 9, then go for section 17. This is I personally believe. Now, after the meeting, statement of claim is drafted. I don't want to teach how it is drafted, but I'm just sharing my 2-3 points. In case if anyone has any additions or queries, you let me know. If possible, statement of claim, make it a very flow of your events. If possible, make a synopsis, because the way we file in before Honorable High Court, try to give a date of events. That makes very easy job even for arbitrator and for you also. Now, I have seen that we have stopped giving the cause of action in statement of claim, because many of them, they say that CPC is not applicable. I don't understand for what reason. Law says that CPC is not applicable, but it doesn't mean that arbitration is as such ki jo diya wo apna. So please put cause of action, and cause of action is the most important ingredient for any suit or pleadings in the court. Cause of action has to be there. Cause of action doesn't mean 2-3 lines. Cause of action means what has happened with you, why you came. What is the reason? Because this cause of action will help you in your prayer relief. Unless until your cause of action is not clear, your prayer has no value actually. Because you are not able to even constitute, you will not be able to even frame your issues, even if it is arbitral tribunal. Cause of action is a very brilliant way to touch your relief, to be read with other pleadings, and then framing of issues. Now, before that, verification comes into picture. Now, most of the times, I know CPC is not applicable, but I always go with the fact that why should I leave any interpretation points when I go to arbitration or any court? Make it life simple. Put in verification. I, falana falana, have in my personal knowledge all the facts. This para is in my personal info. This para is being told by my lawyer. This para is a prayer relief. This para I am assuming to be true, and I am aware of this matter. Make it very simple. Even if you file, your aim has to be file one statement of claim. Don't go for amendment. The moment you try to go for amendment, your whole purpose gets closed, because this is where the delay starts. So for me, cause of action, flow of events along with synopsis, your prayer has to be in the same angle. Same. The moment you try to move on from this, I have seen that it becomes very difficult for you even to prove the case. And I've seen that. This is where the statement of claim comes into picture. From a technical point, don't try to show all your documents on a very first date. Let them file WS and then put in your evidence, whatever you want to do. Because in evidence, in WS, Most of the times you go for admission and rejection of documents or inspection. So play with your papers how you can play. The moment if I am using the word play, it doesn't mean unethical. It is ethical. Sometimes to bring the truth out, you need to be very smart, because opposite party is just waiting for you to not to bring the truth at one point. You need to play smart. Now comes the case of statement of defense. Before filing statement of defense, make it sure whether, if it is not appointed, the tribunal is not appointed by the court, whether the tribunal is valid or not. The moment it is invalid, don't file your defense, put everything on paper, get the matter dismissed and move on. And trust me, 80% of the matters, if you fight for, if you see from financial and other than that, it will be in your favor. They do that the same thing. Go for it. Then you file statement of defense. Now, statement of defense, prayer is important. I have seen that most of the times when we file statement of defense, the prayer is like this: to reject their claim, pass any prayer as per the honorable tribunal. For me, this is not a good prayer. If you can include this prayer, this is my personal view. That's your personal choice. To reject their claim, to make them pay all the arbitration cost and proceedings, to call them to make the payment of all the payment made to the lawyer by the defendant. If you don't have any counterclaim, then any other order or relief as the arbitral tribunal may decide. Go for it. If you don't give a prayer such way, how can you claim your relief later on for your arbitration cost or not? I'm not saying you cannot, but I always say make very simple, make very clear at the very first moment. Let's not wait for the very end and then say I have to do this and this. I have seen arbitrations where they file the professional bills and everything, but they don't file ledger. So basically you lose the matter in that way. So even you file your ledger if possible, if you want to claim arbitral lawyers claims. The moment you file your defense, inspection comes into picture, admission comes into picture. Now this is where your whole strategy starts, because the moment you file your defense. Just one point, in defense, when you file your proceedings, try for a specific denial, not a general denial. Even though CPS is not applicable, but that doesn't mean that you can give a general denial. Don't do that. Be very specific. Even though if you are repeating, give a specific denial and ensure that you are covering your own points. Aage, definitely the law works. Arbitral starts, evidence closes, you take a cross and move on, enter and finish it off. 7, 8, 9, 6, 7, 8, 9. I have given the questions. I will request them to share this PDF with you. If you want, along with the answers, I will give it to you. No doubt about it. Any queries, whatever you want to ask, arbitration or recovery or civil or whatever you want, anything. I'm done with my part.
Sir, I want to ask one question. Once the preliminary objection, say for example, the arbitration is initiated and we move an application for termination of the panel, arbitration panel, and the arbitrator rescues himself from that arbitration. So my question is that, is there a possibility of again initiating, again unilateral appointment can be made by the claimant, say for example, bank. So bank, once the appointment is made, unilateral appointment, we move an application for termination. And then the arbitrator rescues himself. And again, can the bank again make another appointment and again move for arbitration?
If you ask me, no, they have to go to the court, because what they did was against the law. And and I don't know for what reason you must have filed rejection. I'm assuming that they constituted the tribunal not as per the clause, right? I'm assuming that way. If that is the case, then they will definitely go for the chance. But I'm telling you from my own experience, 98% of the times bank will settle the matter with you. Yes, okay. 98%, because they don't want to invest more money in that, because they work on syndicate basis. They don't expect every matter to win. So they will go for the closure with you. And then you are the happiest person on earth, because the settlement offer is very less.
Thank you, sir.
In a case scenario where the SOC is filed, the respondents have filed SOD along with a counterclaim. And now the claimant's strategy is that they are in possession of certain documentary evidence, which will strike off the respondent's counterclaim, or it will aid in at least reducing or whatever the respondent's counterclaim. Now, strategically speaking, as you had referred to this playing with the documents, as per you, can you highlight what will be the proper step when to lodge this evidentiary documents which the claimants have to strike out the counterclaim? What
Okay.
strategy should be used? When should they be brought on record before the tribunal? In this case, it's a court-appointed sole arbitrator.
Okay. Okay. First of all, what happens, when you file a counterclaim, so that becomes a statement of claim of yours, and the opposite party has to file statement of defense, right? So it works in the same way. But let me tell you, the moment you have a counterclaim, now your counterclaim should not be contrary to your WS. So the moment you file your counterclaim, your WS and counterclaim has to be same. So you are opening your defense there itself. So the moment you do that, so now what the claimant has to do, he has to simply deny, saying that we deny your counterclaim, because that is not the right time. In that scenario, both the evidence will be filed at one together, because this is not a case where you will take the evidence first and then, because now here is the case of two pleadings. One is yours and a second is counterclaim. So both the evidence will be filed on a very same date, and this is where the defense starts. So what you can do best is, suppose if you are a claimant, you deny everything, and then you file your evidence on the same date, very same date when he files, and this is where he will get stuck. And you ensure that evidences are being filed together, not one by one.
Can you guide where we can get into actual arbitration learnings? I have attended a lot of webinars, but I'm based in Pune. So, and I just completed LLB recently.
Okay.
So I would like to get into, actual arbitration, not as a tribunal, but as a counsel. And I have a background of more than 25 years. I'm an engineer by profession.
Okay.
So what best could, how should I start?
I'm just asking for myself. You are an engineer by profession for the last 25 years, right?
Actually, I did it in 92.
92. Okay. When the movie.
And then I was in UAE for almost 25 years. And then I came back a few years ago. So I have functional experience in 25 years in electromechanical industry.
Achha. So, okay. My suggestion, I mean to say, what you can do now, you at least just for your information, you can enroll to IIAM. They have a course of knowing how arbitration works out. This is just for your, upgradation sort of. And then you become the part of IIAM. You become an arbitrator there. And then you apply for, since you are an engineer, quite possible that you can enroll to Nana Palkiwala, Bombay Chamber of Commerce or shipping industries, somewhere, such forums. And definitely they will take you on roll, and whenever they have any matters pertaining to your field, they will call for you. But meanwhile, go for some good courses, like you can go to IIM, they have good course. If you want, you can go to CIARB, Chartered Institute of Arbitrator. They have a very good course in arbitration. You can go there. Just understand how arbitration works. And, arbitration proceedings is not that tough. Passing the judgment is something you require the skill. I'm pretty much sure you have. I'm just saying that you should know how the judgment has to be passed. That's it. Because your goal has to be कि मेरा कोई भी judgment appeal में dismiss नहीं होना चाहिए. This is the winning has to be. अगर वो dismiss हो गया, इसका मतलब you have missed somewhere.
One thing I have observed is normally tribunals they have from High Court or Supreme Court judges. तो उसमें opportunity के हिसाब से कम होते हैं.
नहीं ऐसा नहीं है. See, I'll tell you what. It depends. If arbitrators are appointed through judges, I mean to say through courts, definitely they will go for lawyers and them, because see, if you ask me, I'm not favoring anyone. But the moment someone speaks about award is equivalent to decree. A lawyer who has an experience in law, judge, they are the better person to pass an award. I'm not saying about proceedings. Proceedings can be taken care by you. But what about the award? Passing an award is an art. Trust me, it requires a lot of skills. It requires a lot of reading. It requires a lot of understanding what you intend to and what you want to. Because when you pass an award, it is not like this, कि आपने ये लाया ना, आपने ये. Even to pass an ex parte, it requires a skill. I've seen where the orders are passed like this, that the tribunal have issued a notice on this date, they received, they never came, and hence ex parte. No, this is not the way to pass an order. Order has to be in a way that, suppose if it goes for an appeal, it takes care of the minimum rules of the law. That's why. But I'm pretty much sure if you are able to, do some courses on arbitration from a very good institute of 6 months or so, you will be in a position where you will get an arbitration. And trust me, you will get. You have a good experience of 25 years, so you will get.
This is a case which is going on. I'll just explain it to you. This is an arbitration between a society and a redeveloper. which was filed in 2013. It is still going on. And no, the thing is that the society has elected new management committees have come, and unfortunately, now the management committee that has come is in favor of the builder, and they want to go for redevelopment with the same builder against whom the arbitration is filed. And they are not sharing any details with the members of the society. So, what are the members supposed to do in such a case?
File a writ before High Court.
That is the only option, because there is no intervention application.
That is the best option, I'm telling you. Best option.
File a writ. Okay.
Because see, end of the day, arbitration cannot run for more than 18 months. But you're talking about 10 years, right?
That was an earlier act. But this is changed in 2015. So we were filed.
But I agree. But in any case, even if the new law comes, the new law becomes retrospective. No, it will take care of everything.
It should have taken place, but now they are not telling us anything. Nothing is happening.
So what you can do now? What you can do? Issue a letter to them, okay, saying that ki aise sab hua hai. What we want is certified copies of whatever has been ABCD whatever, okay, and mark this copy to deputy registrar, and mark this copy to society and send it if possible members. Try to send this notice once or twice, and then you file a writ saying that. If not writ, because appeal is not there, you file a writ, or if you don't want to go, you just be in a little bit of budget part, then you go to registrar saying that हमारा information हमसे चुराया जा रहा है by committee, because MCS Act is very clear. The managing society has to give the information within 30 days by default.
They tell you section 32. They list out things in section 32 and tell you that this is not for you.
No. See, it's not like this. Most of the I'll tell you what. They will only read out section 32 or something else when you are asking something which is not relevant to society and you. Suppose if you ask what was the legal advice given by advocate to that particular flat member, that becomes a problem.
Correct.
Then you are entering into a privacy part.
I understand.
Right? But the moment you ask, I want an information regarding third party with society affecting me, section 32 or nothing comes into picture. Only section 67 comes into picture.
Okay, fine. So, this is what
दो बार लेटर भेजिए फिर हाई कोर्ट चले जाइए रीट में. Filing a writ itself will give them pani.
Thank you so much.
This is basically a jurisdictional question. I just want to understand what remedy we can get from this. So basically, if the loan is taken from a bank and then there's a default, and the bank initiates the arbitration. But the arbitration is, the notices come from, say, for example, the loan is taken from Mumbai and the arbitration notice comes from Delhi or Kolkata. So what could we do about that? Because the loan is disbursed in Mumbai, the loan is applied in Mumbai, and still we get the arbitration notice from some other jurisdiction. So what steps can we take in this regard?
I understand ये question क्यों आ रहा है, because the thing is that this is the pattern they have done, most of the banks what they have started. See, end of the day, I'm not blaming anyone. I'm just making a statement. कभी पैसा सीधा नहीं निकलता तो मुझे ट्रेड करना पड़ता है. So what is happening is that कि arbitration जो clause बनता है, most of them what they have started doing is that if you are in Bombay, they will keep arbitration in Chennai. They will put Delhi, they will put Haryana. Because they know that the person who will be, with whom we want to claim money, he cannot travel from Mumbai to the regular. It will be an expense to them. So this is where it is one of an issue, no doubt, where, this has to be understood. But at the end of the day, what the law says is that once you sign an agreement, it becomes binding. And no one wants to read the agreement with banks or NBFCs or financial institutions, or even for, say, most of the time, even the business entities, they don't read the agreement. Even you don't read, how many of them have you read the agreement with Blue Dart and DHFL? How many of them that even if suppose one courier company damages your product of 50 lakhs, they will only pay you 3,000. Nobody wants to read. So this is where the problem comes, because law says once you sign an agreement, contract it is enforceable, then don't speak about that. So law works A, B, and C. In your matter, I don't know. I'm assuming that the venue will be in Delhi, and that's why you got a letter from Delhi. So the first thing you should do, read the clause. If the venue is Bombay, then you have a very good chance. But if it is in Delhi, then you need to open a chance. How you can open a chance is that you need to understand what they are trying to do. I will share one example with you. I think so. इससे शायद आपको answer आपको एक अंदाजा आएगा. There was an arbitration done in Bombay by an NBFC. Okay, I don't know to name it. Now, arbitrator was from Chennai. Now, what was happening? I'll tell you. NBFC was in Bombay. Loan Bombay से आया. उनका firm branch Bombay है. Opposite party जिसके against में case किया है, they are from Bombay. Now he gets a letter from a respected arbitrator from Chennai. Now, what is seen is that in that particular letterhead, I don't have that. The address is of claimant bank, phone number claimant bank. There was one number of an arbitrator जहाँ पे आप call करोगे तो कभी लगेगा ही नहीं. So now the question comes, how to reach him unless and until. So what they want is that if you want to reach him, you speak to us. So what has happened that this person, he calls this bank saying that I want to know the details of arbitrator. They say we will not give unless until you make the payment. Now what? This is going on, and this is very practical. If you want to see, you can go and see. You will find many cases. In that scenario, you issue a legal notice to them saying that the appointment of arbitrator is not as per law, and hence I am not able to attend. In case of any order is passed, I shall not be called for any payment. Do that. Play wise, smart, and you are in a very good state to move on.
This on slide you showed, consultation cannot be used as a substitute for mediation, isn't it?
Maybe you are right. But what happens is that the way I take the business term, negotiation always happens before you enter into an agreement. Before.
Okay.
Common parlance, right? Consultation always happens with third party. You don't consult in between. You don't do that. Right? Consultation has to be with third party because you are consulting. Within parties, there can only be amicable talks, discussions. So when this clause came, I am interpreting that as a mediation because other than this, I don't have any other reason to say more than that. Now the question comes, if suppose there was no usage of the term arbitration, then that particular scenario, the clause has no value.
Now, I mean, like, you are giving backward interpretation.
That's what. Because in big companies, what they do, they have a procedure to reach arbitration. Like they have a steering committee, consulting committee, mediation committee, and then arbitration.
Well, nowhere they have seen them use the word consultation. That's why I am asking this question.
This happens actually, because see, that's what I'm saying. When we try to play with words, showing smartness, so it happens. I always believe, use simple words. Who told you that instead of saying back to, you should use revert? Ab karo na simple. Use language which you know.
Now, for instance, another like, this interpretation problem, another is a case in an arbitration actually. It says, in one letter they say that I would like to terminate.
I would like to, okay.
Okay. And then the subsequent letter that I have terminated, so you are not bound by the agreement.
Okay.
Then what is from that date? When the date in which they have told that I would like to terminate has been treated as the date of termination.
Okay, law works like this. Suppose if you enter into an agreement by the name affidavit, and the content of the affidavit is, I am selling my property, right, title and interest to B. Whether that becomes affidavit or sale agreement, it will be sale agreement. What the law says that heading given to the title is not important. What the content says is more important. You can put anything. Like I'll tell you, there's a I don't know about the practice, but I have seen, which I am surprised, affidavit, come declaration, come indemnity bond, come undertaking. So when I was a student, I told my senior कि ये term कहाँ से मिलेगा? He said ये एक term किधर नहीं मिलेगा? आप एक एक करके term join करो कम के साथ.
Irrespective of what they are claiming it to be, statement that would like to terminate cannot be treated as termination is my interpretation.
Agreed, but I really don't know under what contents he has followed it. Like suppose if they are stated like this, I would like to terminate the relationship with you as per the distributorship agreement dated, as per a clause this and this.
There is one statement which has come in the whole letter. It is actually just one statement.
Then what you can do, then you put a revert on it you never issue the termination notice as per the law, because law says if you want to terminate, you give the clause and the para under which you are terminating. And if you don't do that, your termination is not valid. Go for it.
As per the agreement, how you can terminate is as per the agreement, there are ways to terminate, and that has to be mentioned.
Yes, that's what I'm trying to say. You play for your own benefit.
Okay.
Normally, after the counterclaim is filed and the trial has begun, after interims are granted, and if the claimant suddenly feels that due to budgetary concerns or some other issues, technical or personal, whatever, whichever, he wishes to withdraw the arbitration proceedings. Now, in this case, it shall stand dismissed. It shall stand disposed as dismissed out, or the respondent can press for that I have lodged my counterclaim, I want certain relief, some assistance in that, and filing of consentence should be made mandatory. Suppose the claimant wants to just withdraw, अभी बस हो गया भाई, अभी मेरे को नहीं लड़ना है आगे.
हाँ, देखो क्या होता है, I will tell you what. अगर रेस्पोंडेंट ने काउंटर क्लेम फाइल किया है एंड ही हैज अ वैलिड ग्राउंड, वो तो थोड़ी छोड़ेगा आपको, वो बोलेगा मुझे मेरा पैसा लाके दो, राइट? सो वहां पे यू नीड टू अंडरस्टैंड कि कैसे सेटलमेंट करना है. हाँ, अगर आपको लगता है कि फाइनेंशियली आपको अभी नहीं हैंडल हो रहा है आर्बिट्रेशन, then you put an application to arbitrator that I am not in a position to pay the fees. Then the best arbitrator can do is that you reconstitute new arbitral tribunal and go to approach the High Court. Like if you're in Bombay, approach High Court.
No, but when I'm withdrawing the claim itself, when I'm withdrawing the claim and the counterclaim does not survive, no, then if my claim is
agreed, you are withdrawing your claim, but now there's a counterclaim, no?
So if the parties negotiate and settle, then it won't be an issue.
Yes.
But then lodging of consent terms is a must in the interest of both parties.
It is better because if I'm opposite party, I have a fear, no? Today, if I'm suppose आपको पैसा लेना है उससे, right? सब कैलकुलेशन करने के बाद ऑपोजिट पार्टी क्या बोलेगा, मैं आज पैसे दे रहा हूँ कल वापस मांगेगा, तो सेटलमेंट लेटर दे या तो नो ड्यूज लेटर दे. Now suppose if you have to pay them, you will do the same thing. It is always better to have consent terms so that that particular matter is closed forever. Again, you don't go to the place of the court saying that कि मुझे वो पैसा नहीं मिला. ऐसा है. So it's better to have settlement or consent.
And the second I have typed in that normally how many times we should send a notice, and like दो बार courier से या first courier, second registered
courier, आप courier से भेजो ही मत. The thing is that हो सके तो आप क्या करो, आप एक ही बार भेजो, post से भेजो, then send by email, then send by WhatsApp, and then send one email to them saying that we have sent you by this and this is the final notice, and then arbitration notice को एक ही बार भेजना, section 21 वाला. Don't send it twice. Then the interpretation will come into picture for 60 days. एक ही बार भेजो. Legal notice आप दो बार भेजो, that's okay. Issue the notice only once for section 21.
No, I am asking for normal legal notices. Normal.
हाँ, मैं बोल रहा हूँ ना, आप दो बार, आप एक बार भेजो तो भी बहुत है, बट आप उसको मोड चेंज करो. एक बार पोस्ट से भेजो, फिर आप ईमेल करो, ईमेल है तो फिर व्हाट्सएप कर लो, बराबर है. अगर आपको लगता है पोस्ट से रिटर्न आ गया है तो कुरियर से भेज के देख लो, बट कुरियर भी आप कौन सा यूज करोगे, ब्लू डार्ट यूज करना है तो DHFL करना, विच आर रेप्यूटेड, बिकॉज आप लोकल कुरियर करोगे तो उनका कोई वैल्यू नहीं है व्हेन इट कम्स टू डिलीवरी ऑफ पार्ट. बट लॉ सेज पोस्ट इज मैंडेटरी. और मान लीजिए कुरियर उसको मिल जाता है तो आप फिर से पोस्ट करना, देन यू प्रूव इट टू द कोर्ट कि इंटेंशनली इज नॉट टेकिंग द, आपका काम हो गया.
Post should be registered post or normal speed post, registered post. And sir, last one, normally this question arises that during an online hearing of a arbitral tribunal, the counsel or the parties should address the sole arbitrator as Milord, or he should or arbitrator sir, or what is the
sir बोलने का.
Sir, okay.
Bas.
Yes, we agree on that.